Hello friends, welcome to Inside Psyche Initiative. In today's video, we are going to discuss about distribution of wealth. We are living in a world where income inequalities are growing. Around the majority of the wealth is controlling by top 1% of the population, and only the 5 to 6% of the wealth is controlling by the rest of the 50% of the population. This is not about the numbers. This is about what kind of impact is creating on the people life, which is the economic inequalities. In these kind of times, so the recent judgment or recent observations by the Supreme Court regarding the distribution of wealth, and Supreme Court forming 9-judge bench related to the distribution of wealth. And while you are distributing the wealth, whether the private property comes under this particular jurisdiction or not, these are the issues we are going to discuss. And in this video, we mainly going to discuss about constitutional provisions related to property and some of the landmark judgments regarding the distribution of wealth. So these are the things you can learn. Okay. By the way, so this topic is related to some of the social aspects as well as the constitutional element of the Indian Constitution. So the learning objectives are context and the Article 31C, some of the cases related to the distribution of wealth, Supreme Court case, significance, and finally conclusion. Regarding the syllabus mapping related to General Studies Paper 2 Constitution. Let's check out the context. Supreme Court under the Chief Justice of India, they decided to address whether Article 31C still exists while hearing a case on the government's ability to acquire and redistribute private property. Here we are going to discuss about Article 31C and some aspects related to this particular provision. First, let us go back into somewhat historical perspective. In India, wealth generally associated with the ownership of the land. Okay, so wealth associated with the ownership of land. During the Britishers' time, majority of the land either directly controlled by the British administration or the tax collection responsibilities they given to the Jamindars. Because of that, even though the Britishers left India, majority of the Jamindars, they left with huge amount of the lands. To improve the distribution of wealth, Government of India after independence, they started land reforms. It's all about distribution of land from Jamindars to landless poor people. But at that time, one of the major obstacles came from the Constitution. That is, in Constitution, Article 31, right to property was there, and even Article 19, Clause 1, Subclause F was there, right to having the property. These two articles, they stood as one of the major obstacles to implement the land reforms. To overcome, Parliament enacted the first Constitution Amendment Act, and which added Article 31A and Article 31B. Article 31A is saying that certain land reforms, while they are implementing, even though they are in violation of the Article 14 and Article 19, they are still valid. They cannot say as constitutionally invalid. So the Article 31A mainly talks about land reform laws which are in violation of Article 14 and Article 19. Then Article 31B, it says that, and of course Article 31B also added the 9th schedule, and it is saying that any law related to land reform, if it is kept under the 9th schedule, then even though that law is violating any fundamental right, it cannot be questioned in the courts. That is regarding the 9th schedule. So in fact, 9th schedule given broader protection to land reform laws compared to Article 31A. Okay. Now tell me guys, in which case Supreme Court mentioned that whatever the laws added to 9th schedule after 1973, they will come under judicial review. Okay. In which case Supreme Court mentioned that laws added into the 9th schedule, they comes under the judicial review if they were added after 1973. What is the name of the judgment? So now, so as this struggle is going on, again in Article 31C came into the picture. Article 31C is saying that in the implementation of the DPSP, that is especially in DPSP, Article 39B and Article 39C, Article B and Article 39C. Article 39B deals with property related to the community should be used in the best interest of the community. It should not be used only for the personal gains of the few people. Article 39C is saying that concentration of the wealth should be reduced. So, in the process of implementing the Article 39B, Article 39C, still we can give more priority over Article 14 and Article 19. This is the observation of Article 31C. Okay. Now the question is, while the implementing of the provisions of Article 39B, 39C, especially under Article 39B, that is distribution of the community wealth, the definition of the community wealth, does it confine only to the public property or does it include the private property also? That is the question before the court. The nine judge bench is going to decide this particular issue. So, you must have a clarity on 31A, 31B and 31C. So, these are the constitutional provisions regarding the distribution of wealth related to this particular topic. And related to this, obviously, certain Supreme Court cases were also there. The first one is, it started way back in the 1951. In 1951, Supreme Court given a judgment that, okay, in 1951, when the first constitutional amendment was challenged, okay, so in this case, Supreme Court observed that fundamental rights can be amended by Parliament. Fundamental rights can be amended by Parliament. This was the observation of Supreme Court. Okay, this was the observation of Supreme Court in 1951. Then again in 1967, Goraknath case. Okay, Goraknath case. This case is the Shankari Prasad case. 1951 Shankari Prasad case. Whereas in 1967 Goraknath case. Here Supreme Court observed that fundamental rights cannot be amended by Parliament. Fundamental rights cannot be amended by Parliament. Then who can amend? Amended by Parliament. Okay, who can amend then? Then Supreme Court clarified that Constitution can be amended. Constitution, fundamental rights. So Constitution, fundamental rights can be amended only by Constituent Assembly. Only Constituent Assembly can amend the fundamental rights. This was the observation in 1967 Goraknath case. Then this was challenged. To overcome this, Indira Gandhi government, they came up with the 24th Constitution Amendment Act 1971. Okay, through this they added the Article 368 Clause 3. It is saying that Constitutional Amendment does not come under the definition of the law, so that through Constitutional Amendment we can do anything and even we can violate the fundamental rights also. And this was challenged in the Keshavananda Bharati case. 1973. In Keshavananda Bharati case 1973, Supreme Court clarified that as fundamental rights can be amended by the Parliament, okay, that means it's reversed the judgment in the Goraknath case, and in this case Supreme Court also observed that as long as the Parliament is amending within the limit of basic structure, Parliament can amend the Constitution in whichever way they like. So that they added the concept of basic structure for the first time in Keshavananda Bharati case 1973. And to overcome this, Parliament came up with the 42nd Constitution Amendment Act 1976, which given unlimited constitution amendment powers to Parliament. Of course, this was struck by Supreme Court in Minerva Mills case. 1980. In this case, Supreme Court struck down the provisions of Article 368(4), Article 368 Clause 4 and Article 368 Clause 5. These two provisions, they were struck down by the Supreme Court. So this is the information regarding the various landmark judgments related to the distribution of property. And we also already discussed about the various constitutional provisions regarding the distribution of property. Now let's see the news, this particular notes. We already discussed regarding the Article 31C and Article 39B and Article 39C. And this particular case, Keshavananda Bharati case, 42nd Amendment, everything we discussed. Minerva Mills case, it struck down the Article 368 Clause 4, Clause 5, and it also struck down some provisions in the Article 31C also. In this particular case, the Supreme Court case is involving challenging the Chapter 8A of the Maharashtra Housing Area Development Act 1976. This act is allowing the government to acquire and redistribute the private property also. This legality is now challenged in the court. Now court is examining this particular thing, and the petitioners are arguing that private property should not be covered because this particular amendment, act which came in 1976, but after 1976 this Minerva Mills judgment came in 1980, so we should stick to that judgment. Government is arguing that doctrine of revival should apply even the pre-amendment position of Article 31C. That means even though the Supreme Court given the judgment in Minerva Mills case, we can go back before the judgment and we can implement the earlier stand of the Article 31C. So that is government is arguing. Let's see what the Supreme Court will give the judgment. The significance. This particular case is raising questions regarding the relation between the fundamental rights, DPSP, and the amending powers of the Parliament. And the Supreme Court ruling, it is going to have far-reaching consequences regarding the constitutional jurisprudence and balance between the fundamental rights and DPSP. Yesterday's video question. Which of the CAPF, Central Armed Police, is called as Crown's Representative Police? Central Reserve Police Force, CRPF, is considered generally as Crown Representative Police. Next, today's video question. Today's video is, as far as the armed forces are concerned, the fundamental rights guaranteed under Article 14 and 19 Constitution are, okay. So regarding the armed forces, Article 14 and 19 regarding this, so which one is right? Mains question. A right of movement and residence throughout the territory of India are freely available to the Indian citizens, but these rights are not absolute. That means these fundamental rights are not absolute, they are only limited. In that, comment on this particular mains question. As we reach to the end of this video, in this particular video, we mainly discussed about the issues regarding the distribution of wealth and raising income inequalities. In this particular aspect, the act made by the Maharashtra government, constitutional provisions related to that particular act, and a landmark judgments regarding this particular concept. So these are the details we covered, and this is the detailed analysis regarding the redistribution of property. I hope this video is useful to you. Thanks for watching this video. Have a great day. Jai Hind.